It's Nolan. Now that I got your attention, I guess I should probably mention I got a new album available now on my site. Nigga, fuck all that whining and bitching. You looking for greatness, then I'm the description. Dropping me by like a prison. Twisting your brow like ignition and split, nigga. That's what I call on the vision. I'm finna infiltrate, you cannot imitate. I'm from a pedigree, this is not Triple H. I took a road, you can't travel like Triple A. Do the impossible, just like a triple play. Genuine energy, I am not Timberlake. But a nigga too insane. Truck full of money, but to pull up in the ring. So I can give a what the fuck about what a nigga think. I'm on some new shit, elevated my rubric. I'm an industry nuisance, giving my 2 cents. Telling niggas what the truth is. It ain't even about music. Everybody wanna know the cheat code. Bitch, I got bops on reload. I was just on live 2 hours straight. Ain't playing not one repeat song. I'm ready for the spotlight. I was on the block like a stoplight. Every day I catch lightning in the bottle. The niggas told lies, but not hitting spots twice. Couple years I was living on fried rice. Like a tree when I got to eat Popeyes. Gotta feed them, I get your whole top 5. Spit heat on top like a rabbi. It's Nolan. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everyone is doing well out there. Now, in this particular video, we're going to be going over Megan Thee Stallion and Emilio Garcia, aka Emilio Coochie. Now, we talked about this many months ago, outlining Emilio's lawsuit and everything that he had going on. It's been a while since we talked about this. Of course, this is Megan Thee Stallion's former photographer, videographer. They worked for some time during the pandemic. Basically, Emilio was with her from early on throughout the pandemic. And unfortunately, at a certain point, he started receiving less money because he was performing less work. Right? Because the pandemic was dying down. Tour dates were dwindling down for Megan. She had less for him to do. And he then decided to come out and create some sort of sexual harassment lawsuit and basically say that he should have been paid as an employee on payroll and all of these different things. Basically stating that he shouldn't have been subject to his salary or his income changing due to whatever she had going on. And again, he put out sexual harassment allegations against Megan Thee Stallion for allegedly subjecting him to be a witness to her engaging in sexual activity with another woman abroad, out overseas. We're going to get to the specifics of it. We're going to take a blast from the past real quick to revisit all of those allegations that he had. And then we're going to give y'all an update because he seems to be in a very rough position. All right. This case was originally filed in California for Emilio Garcia. Since then, Megan Thee Stallion's legal representatives, Alex Spiro and others, petitioned to the courts that this was not a California matter because her business and Roc Nation business, both companies that Emilio sued, do not run their businesses out of California. They only conduct business there, part-time. So the case was then moved to the state of New York. Now, the issue that Mr. Emilio is having is that his legal representation has not been keeping all the way abreast to everything going on from the courts. And it looks like his main legal representation may not even be licensed to work in New York. So just giving y'all that, and we're going to do a quick refresher, and then we're going to give y'all the updates because it looks like he may end up having to either pay money, he might find himself in a position where he has to end up paying rather than receiving anything, or this case could be thrown out completely if they don't get on top of their ish. All right. Now let's just revisit what was happening. All right. About approximately 5-6 months ago, Emilio Garcia came out and said that Megan had performed some form of harassment and fostered a hostile work environment upon to him, right? Emilio worked as a personal cameraman for Miss Megan from 2019 to 2023 and alleges that he was stuck in a moving car with Megan while she had sexual relations with a woman. According to the lawsuit, a copy of which was obtained by other platforms, Garcia traveled to Ibiza, Spain with Megan in June of 2022 and was in a car with her and another woman when they began doing the do. He said he was unable to leave because the car was moving. All right. Garcia says he felt uncomfortable and shocked at the overall audacity to do this right beside him. Megan Thee Stallion asked him if he was in the SUV and confirmed that he was, the lawsuit says. She told him not to speak about what he saw, and Garcia also said in his lawsuit that she hurled fat-phobic comments at him, calling him a fat bitch and telling him to spit his food out, stating, "You don't need to be eaten, I guess, with your fat ass." These are all alleged. I don't know. And the whole confirming that he was there, that's basically trying to say that she was inebriated and was not fully recalling the events that were happening in the car. So she went to ask him if he was present for this engagement she was taking place in. Right? Allegedly. He says, to hear someone who advocates about loving your body tell me these things, he felt degraded. Right? Now, Alex Spiro, on the other hand, says this is an employment claim for money with no harassment claim filed and with salacious accusations to attempt to embarrass Megan. That's what Alex Spiro said. He says, we will deal with this in court. We've gotten to the part where they're dealing with it in court, and I don't know what Emilio's going to do. He sounds to be a little bit flustered and confused. Okay? Now, as of May 30th, Megan Thee Stallion did respond to the lawsuit through her lawyers, who say that the claims are outlandish and fabricated and that there is no truth. They say plaintiff is a con artist who is manipulating the judicial system to act as his publicist and bullhorn in a desperate attempt to boast his failed singing career while trying to tear down the successful career of Miss Pete. All right? He does moonlight not only as a photographer and videographer, he is also some form of singer. He also tried to impose some sort of exclusivity clause with Megan, basically stating that she's the only person that he was working with. But during the time that all of this was happening, he was still posting current work with other clients. So that even was kind of debunked. And I know there's some people out there that feel like I just be going up for Megan and I don't listen to the facts and all of this type of stuff. But the facts that people be presenting be having a lot of holes and gaps in their stories. That's all I'm saying. If you don't like it, you don't have to listen to me, by the way, but I appreciate it. They say, angry at the loss of his high-profile gig and his exile from the inner circles of stardom, plaintiff filed a factually and legally frivolous complaint in Los Angeles Superior Court, plagued with falsehoods, misrepresentations of fact, and outlandish claims. All right. Garcia's attorney at the time, Ron Zambrano, who is one of the people having issues, he stated, Megan just needs to pay our client what he's due, own up to her behavior, and quit this sort of harassment and fat-shaming conduct. He basically was urging her to just go ahead and pay so we don't have to go to court. I wonder why he was so eager for that. Most attorneys will say we will get to the facts in court. He said, now fuck that, just pay us. But nobody wants to hear the gaps in the story. He continues, Emilio should have never been in a position of having to be in this vehicle with her while she had sex with another woman. Inappropriate is putting it lightly. Exposing his behavior to employees is definitely illegal. According to the lawsuit, Garcia alleged that after the trip, he went from earning a monthly rate of $4,000 to being paid on a task basis, right? So she was paying him a agreed upon $4,000 monthly just to take care of everything. And then shortly thereafter, he started being paid for each thing that he did, each shoot that they conducted, or each event that she was going to in which he was going to film. So he felt like he was being shortchanged for his work. But again, the schedule also changed at different points. Okay. Lawsuit says Garcia essentially worked during all waking hours of the day. This is what they're claiming. Also answering calls and running other tasks under her direction. He claims he was denied overtime pay and regular breaks. In June 2023, he was already planning on quitting, Roc Nation told him that his services were no longer needed. So if you wanted to quit and they told you your service was no longer needed, why are you mad? NBC reports that Garcia is seeking more than 6 figures in damages. According to the lawsuit, he's also fighting for unpaid wages, interest on the unpaid wages, or unpaid overtime wages. I think he also wanted wages for breaks and lunch breaks and all of these other things, because again, he filed that he was an employee of Megan Thee Stallion's company rather than an independent contractor. Okay, just giving y'all the catch up, because it's been so long since this thing has been talked about or even a relevant topic. But new information about this case has surfaced in the last week or so. All right. So November 12th, just a few days ago, Ronald Zambrano, which is Emilio Garcia, his attorney, they had a court date, I believe, on the 11th, and on the 6th of this month. So there was a court hearing on November 6th in which they didn't show up. Okay. They were no show, no call, no show, no nothing. So then, Ron Zambrano comes to the court and basically tries to explain why they didn't show up in court. So I'm gonna give y'all this rundown, and this is shout out to Megan Cuniff, who's been keeping the people abreast on this thing. This is 19-page filing. I don't want to go through all 19 pages, but I do want to go through the basic things to just, again, keep people updated, especially the hotties who may not have seen this and the people out there that are interested in this type of stuff, right? So, United States District Court, Southern District of New York, Emilio Garcia, plaintiff versus Roc Nation, a Delaware business organization, Hot Girl Touring, LLC, a Delaware business organization, Megan Thee Stallion Entertainment, Incorporated, a Delaware business organization, Megan Thee Stallion, an individual, and does one do blah, blah, blah. Roc Nation, I think, was removed from the original lawsuit, seems to me. Okay? Excuse me. So Ronald Zambrano swears under penalty of perjury pursuant to 28 U.S. Code 1746, stating, I am an attorney duly licensed to practice law in the state of California. I am a partner and employment litigation chair at West Coast Trial Lawyers, APLC counsel for plaintiff Emilio Garcia in the above referenced matter. My firm's address is 1140. Let's not do that. Not putting their address out. My email address, blah, blah, blah. Our firm number is as noted. I'm an attorney in good standing in the state of California, the Northern District, the Eastern District of California, Central District of California, Southern District of California, and the Ninth Circuit Court of Appeals. I respectfully submit this declaration in response to the court's November 6th, 2024 order, why I should not be sanctioned for failing to appear in person to the conference on the same date, right? So they're trying to avoid penalties. Mr. Zambrano claims, I was never served the court's order about the November 6, 2024 conference. I have not received an ECF notification since October 4th, 2024. The date Judge Herman D. Vera transferred this case from the Central District of California to the Southern District of New York. So they're saying ever since this case was moved from California to New York, somehow there's been a lapse in information being received. They say a review of the PACER docket on this matter, PACER ECF notifications, blah, 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 have not been served to anyone in my office to date. He says, I would not have known of any conference's existence had defense counsel not emailed me on October 22nd to schedule a meet and confer meeting. It was not until October 24th, 2024, meet and confer meeting with defense counsel that I learned a November 6, 2024 hearing was even set. So at some point, they were privy to this November 6th date. They found out on October 24th, right? A draft letter to the judge in anticipation of that conference was provided, and that is when I saw for the first time a case number for the Southern District of New York was issued. I then checked the PACER activity with that case number and found a flurry of ECF activity unbeknownst to anyone at my firm, as well as the order for the November 6, 2024, which stated, "It is hereby ordered that counsel for all parties participate in an initial pretrial conference with the court at the time listed below. Initial conference set for November 6th at 4 p.m. in courtroom 12C, blah, 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 New York, before Judge Gregory H. Woods." I'm trying not to put too much specifics in terms of case numbers, addresses. This information is available, but out of responsibility on my platform, I just don't want nobody to try nothing fancy or fly at any of these locations, right? In retrospect, I should not have assumed that I could have participated in this conference remotely by either telephone or video conference, because the word "in person" was not included in the court's order. This mistake was compounded by the widespread adaptation of remote participation in court hearings in both federal and state courts in California. I believed in good faith that I could participate remotely in the November 6, 2024 hearing. So basically, this attorney for Emilio was under the impression that they would be able to join some sort of Zoom conference or by audio rather than show up to the actual court date in New York. Right? They continue, "What added to my false hope was the number and access code found in the court's individual rules of practice in civil cases, section 2C, telephone conferences. Again, in retrospect, I made the erroneous assumption remote participation was allowed. Upon discovering on October 24th, 2024, for the first time, the flurry of activity since docket 42, I emailed the court's chambers email in an attempt to expeditiously advise the court I was not receiving any activity on the matter. I was doing everything possible to catch up and find local counsel. Attached is a true and correct copy of my October 24th, 2024 email as Exhibit A." So Ron, or Mr. Zambrano more specifically, is stating that they're trying to find a legal representative in the state of New York that can show up, because he can't. On November 6, 2024, believing I was able to participate remotely in the hearing of same date, I dialed the number and access code, found the court's individual rules, and entered access code blank followed by the pound key. As reflected in the emails I sent to opposing counsel and the court during the pendency of the November 6, 2024 hearing, I wrote that I was on hold until 1:10 Pacific or 4:10 Eastern, when the call ended with an announcement that the conference is ending now. Okay? So they tried to make some sort of concession that would have allowed Mr. Zambrano to join via telephone. He called in. He says that he was on hold until 10 minutes after the hearing began, because it was supposed to start at 4. He was on hold until 4:10. And then he heard an announcement that the conference was ending. Despite requesting what transpired at the hearing, I have yet to hear a response from defense counsel. I did not get an ECF notification of activity regarding the newly set November 18th date, which is just in a few days, or that it was in person, or that there was an order to show, because why should I not be sanctioned for failing to appear in person on November 6th? Nor did anyone that was at the hearing give me any news of what transpired. I learned of the order by checking the updated PACER activity on November 7th. I will be participating in person for the November 18th, 2024 conference set for 4 p.m. in Judge Wood's courtroom in the Southern District of New York. So at this point, Zambrano does plan on showing up. Based thereon, I respectfully ask the court not to sanction me for failing to make an in-person appearance for the November 6th conference. Specifically based on the above, I believed in good faith in-person participation was not required, and I believed I would be able to attend via telephone conference. I apologize to the court and all counsel for my mistake and for any inconvenience caused by same. I declare under penalty, under the laws of the United States, the foregoing is true and correct. This was dated November 11th, so this was submitted to the courts. Okay. And at this point, they start showing documentation of email. When was this email sent out? October 24th to the court. I am counsel for plaintiff Emilio Garcia. And basically stating that they're having trouble getting in contact with the courts. They have a follow-up from November 6th stating that they tried to connect with the phone number and access code. We got this from the judge's individual rules. My attempt resulted in the call hanging up. So they weren't privy to any of the proceedings that happened during that pretrial meeting conference. Okay. They got another email here. They say, Ron, okay, I guess this was sent to him from someone on that side, from the court side. They say, Ron, we believe you already have copies of the court's conference order and Judge Wood's individual rules of practice, but out of an abundance of caution are providing a copy of both, which I will not be showing. So up to this point, there seems to be compliance, but Emilio's lawyer didn't show up. Now, Megan's attorney, as of today, has issued a response to the courts, basically stating that Ron Zambrano is not licensed to practice law in New York, which would be an issue from the legal bar and all of that stuff. And Alex Spiro is requesting that Ron Zambrano and Emilio Garcia be sanctioned, aka face penalties for basically inconveniencing the court. And I'm going to go through it. So they say, Dear Judge Woods, this is the judge presiding over the case. Pursuant to your Honor's order to show cause in the above referenced action, defendants Rock Nation, Megan Thee Stallion, Hot Girl Touring, Megan Thee Stallion Entertainment Incorporated, submit this joint response in support of the court's order to show cause regarding sanctions for plaintiff's counsel Ronald Zambrano. Defendants respectfully request that the court impose sanctions, penalties, financial penalties, by the way, dismissing the action without prejudice, allowing plaintiff to refile when he secures New York counsel, and 2, levying a fine in the amount of the attorney's fees associated with defense counsel's time spent attending the initial November 6th status conference. So they want this case to be dismissed, stating that they can refile when Emilio finds a New York licensed attorney. And 2, we also want for them to have to pay our attorney fees, which we've been charging our client, because they're wasting our time, right? And not showing up to court dates, even though we showed up. Just simplifying the jargon here. Furthermore, they state sanctions are appropriate for the following reasons. First, Mr. Zambrano is not licensed to practice law in the state of New York or the District Court for the Southern District of New York, yet attempted to appear at the November 6th initial conference telephonically and represented that he will appear in person on November 18th. Declarations of Ronald Zambrano, R.E., order to show cause. Second, Mr. Zambrano did not request an adjournment of the initial conference and has not explained his failure to do so. Finally, Mr. Zambrano's dilatory conduct amounts to a failure to prosecute. Okay? So again, they going in on his ass legally, or at least attempting to. Say the background, the action was removed to federal court in the Central District of California on May 29th. All parties noticed their appearances on the docket, and all counsel relied on the PACER ECF system to provide notice in the action. As such, when this action was transferred to this court on October 7th, defendant's California-based counsel received Contemporaneous ECF notifications sought admission to SDNY Pro Hack Vice and noted the appearance of New York counsel. Given that Mr. Zambrano received all prior ECF notifications and appeared in person for the September 12th motion to transfer hearing in CD, California, defendants had no reason to believe that Mr. Zambrano had issues receiving ECF notifications, which was in Ron Zambrano's filing, saying that he was no longer privy to all of the updates since the case was moved from California to New York. Alex Spiro, Megan Thee Stallion's lawyer, and others are saying, well, if he was up to date on everything else, and this is all part of the same case, although it's been moved, how is he not getting notifications? Right? And he showed up to the September 12th hearing telling him that it would be moved. On October 22nd, defendants emailed Mr. Zambrano to arrange a meeting and confer pursuant. This is the same thing that Zambrano said to the order and attached a proposed draft status letter and case management plan. Zambrano defendants also asked that he advise whether plaintiff had retained New York counsel. Mr. Zambrano did not answer that question. So they asked, hey, do y'all have somebody who's legally allowed to practice law in New York that's going to help with y'all on this? Or what do you plan to do? He never answered the question, according to Alex Spiro, which I don't know. We're just going off of hearsay through the legal professionals. Right? On October 24th, the parties met and conferred. Shortly after the meet and confer, Mr. Zambrano contacted defendants advising that his office hadn't received anything on this case since October 4th. Mr. Zambrano then emailed, I don't think the New York court has our emails. We will call the court first thing tomorrow to see how to fix this. Mr. Zambrano then emailed Chambers requesting guidance on this issue. In response, the court instructed him to review the judge's individual rules, which direct counsel to the court's ECF help desk for questions regarding the ECF system, rather than to the district judge presiding over the case. So they told him to go through the help desk rather than try to contact the judge directly. On October 29th, Mr. Zambrano approved the joint status letter and case management schedule, which the parties submitted to the judge on October 30th. At 6 p.m. the day before the conference, Mr. Zambrano emailed the court and defendant stating, I still haven't found local counsel. I'm currently working with someone in New York to see if they'll allow me to participate. On November 6th, Mr. Zambrano failed to appear at the initial pre-trial conference. At no time thereafter did Mr. Zambrano request what transpired at the hearing from defendants. As of November 12th, Mr. Zambrano has not declared that he secured New York counsel or that he resolved his technical issues. So they're saying you're making no progress. You don't have nobody that's legally allowed to practice law in New York, and y'all are not moving anywhere in that process, yet y'all want the judge and the court to be lenient on y'all for this. Sanctions are warranted. Plaintiff's counsel is not qualified to appear in the action. They say it is unlawful for a person to practice law in New York without having first, inter alia, been duly and regularly licensed or admitted pro hoc vice Judicial Law 478. This section is broadly interpreted to include legal advice and counsel as well as appearing in the courts and holding oneself out as a lawyer. Here it is undisputed that Mr. Zambrano is not barred in New York, meaning not legally recognized. He also has not applied for nor been granted pro hac vice admission in this action, unlike defense counsel who timely applied. And despite his representations that he is in the process of obtaining legal counsel, Mr. Zambrano has yet to do so. Notwithstanding this, Zambrano attempted to appear remotely on November 6th, submitting a declaration, and claims he alone will be participating in person for the November 18th conference. So his presence is kind of null and void, even if he does show up, because who the hell are you? You're not licensed. Similar conduct has qualified as the unauthorized practice of law. They then stated, of course, in all of these documents, they give examples. Accordingly, Mr. Zambrano should be sanctioned in the form of dismissal of the action without prejudice for plaintiff to refile his complaint with proper New York counsel. They also state that he failed to request an adjournment. Mr. Zambrano was on notice that an initial conference was scheduled and that it would take place, yet he never sought adjournment nor explained why he failed to do so. Instead, Mr. Zambrano claims he believed in good faith that he could participate remotely, but nothing in the court's order provides for remote participation. The order unambiguously states that the conference will take place in courtroom 12C, Daniel Patrick, whatever courthouse. Moreover, on November 5th, the court issued an order moving the courtroom from 12C to 26B. Y'all, Zambrano just missing all the information. He didn't even know that the courtroom was moved. Damn it, man. All defendants understood this to mean an in-person conference and appeared in person. Mr. Zambrano was the only attorney who did not appear. His failure to follow this simple instruction, compounded by his failure to seek adjournment in the event he could not appear in person, warrant sanctions for wasting the court and the defense counsel's time. Mr. Zambrano has failed to prosecute plaintiff's case diligently. Dismissal is appropriate. That is the request from Megan's legal team. They say, hey, these motherfuckers is wasting time. They're not showing up. They're not legally barred in the state of New York. This is a load of horse shit. Please get this out of here. Oh, man, you got a little bit more to go. Stay with me. Mr. Zambrano declared that he has not received an ECF notification since October 4th. And that notifications number 43 through 57 have not been served to anyone in his office. His admission is puzzling. He blames his conduct on a failure to receive notifications in another party he believes would be serving his office with the docket filings, but he was directed by the court to contact the court's ECF help desk to resolve these issues and apparently did not. Moreover, Mr. Zambrano represents plaintiff. It is his obligation to prosecute this case diligently, including by remaining abreast of developments in scheduled court appearances and regularly checking the docket. Nor has he taken the appropriate steps to advance the action since it was transferred to this court, including by failing to apply pro hac vice or securing legal counsel and failing to obtain leave of court for additional time to address these outstanding issues. That's a key thing too, failing to obtain leave of court. Basically asking for additional time. So you're not requesting additional time. You don't have the notifications you claim. You're not showing up. So all of the things that would possibly give you some sort of paper trail to say, hey, shit is falling apart. I don't know what's going on. You're not taking the proper precautions to ensure that your client gets the best representation possible. Accordingly, the court should sanction Mr. Zambrano by 1, dismissing the action without prejudice and allow plaintiff to refile with New York counsel. 2, levying monetary sanctions on Mr. Zambrano for attorney's fees in the amount of $6,000 for time spent attending the initial November 6th status conference. So they are requesting the $6,000 payment and to dismiss this bullshit until they can reconvene with proper counsel. So, sounds like a bunch of legal mumbo jumbo, I'm sure. But basically, they want this thing tossed out. They feel like Emilio's representation is incompetent, which is basically reflecting poorly on Emilio, right? Because if he's not there, his lawyer's not there, his lawyer's not able to keep up with everything that's happening in the PACER notifications, then why are we here, right? You're the one that's supposed to be prosecuting. You're supposed to be giving info and proof and all of the things that would basically, make Megan liable to pay you. make you susceptible to some form of retribution. But y'all ain't even over here showing up to fight. So why do we have to keep showing up? I think that's fair. And perhaps they're not showing up because they know they ain't got nothing. I don't know. I can't say that for sure. I can't say that with any ounce of certainty. But it does reflect poorly on Emilio and his legal team. Especially when they found, like, y'all kept up to know that Megan and them requested that this shit go to New York. So if all of this was happening, y'all should have been convening with somebody in New York to say, yo, if this thing ends up going to New York, what are we going to do? Who can we get? Who do you know? You ain't got no colleagues on the other side of the map? What the fuck you been doing? But hey, we already know what people are going to say. I already know what people are going to try to say about me, those that don't like Megan. But just wanted to give y'all the update. That's where we stand. She might remain the Teflon Don in the courtroom. I don't know, man. Let me know what y'all think about it down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I'll catch y'all on the next one. Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef for computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross them out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.